interaction about it. And therefore, I would like to share what are the idea of a constitution ought to be, especially for those who may not have to deal with it on a professional basis, like non-lawyers, or even those who don't come from the political science or the arts stream, to just have a better understanding of constitution, because understanding the constitution would mean that we become better citizens, we become better Indians. And unless and until we don't understand this precious document called the Constitution of India, we can never aspire to be better citizens and better members of the society. So therefore, let's just understand what is constitution and how is it different from any other law. For example, Delhi University is established under the Delhi Universities Act. Now, so we have various acts and various laws, rules, regulations, statutes, etc., etc. The university has several ordinances. It functions under various law. The constitution is right at the top. So it can be called as the Gangotri of all laws. Everything else flows from the Constitution of India. So today, if I can get admission into Delhi University pursuant to a law that enables Delhi University to admit students, Delhi University is able to do that because the Constitution of India, ultimately, if you go upstairs, provides for it. Something as simple as you violating a red signal and getting challaned by the police. Now, the police is empowered to do so because the Constitution of India empowers it to do so. You apply for any educational or technical institution. There are various systems of reservations or various system of categories under which you can apply. Or the NEET exam, for example, right now that we see. All of it in your life, whatever laws that you encounter, and an average citizen would encounter with a plethora of laws or legal system from during his education, during his employment, and even every day during our lives. Everything is relatable to the Constitution. The Constitution permits that. That's the reason everything else flows. So first and foremost, what we must understand that it is the first law. It is the basic law. It is something that provides for all other laws. So each and every law, howsoever minor or howsoever major it might be in our country, owes its existence courtesy to the Constitution of India. So that's the first thing that we must understand. And why is the Constitution then so important? And what is the difference, say, between a country having a constitution or a country which does not have a constitution? The constitution is a very important trigger point to ensure that that country is truly a democratic country. Now, before constitutions were there, the first ever written constitution was the American Constitution, 1787. So it's of a very recent origin, this entire concept of writing a constitution and ensuring every law in the country goes as per the written constitution. It's a very relatively recent phenomenon of just 200-300 years old. But there have been countries which have been existing for thousands of years. Now, how did they exist? The most popular form of government was the monarchical form of government. Now, you had a monarchy, you had a king. So after the king died, his son sat on the throne. Then when he died, his son sat on the throne. So the sovereignty, that is the most important power in any country, it vested with the king and with his successors, the ones who would follow him as the king or the emperor. That is what we call as the sovereign power. But when India got independence, and for example, before independence also we can see, the sovereign power was in the hands of the British king or the British queen. Of course, exercised through the Prime Minister of Britain and the Council of Ministers. But the sovereignty, that the king or the queen, today we have Queen Elizabeth. Unfortunately, a day will come when she no longer will be there, and the throne will pass on to, say, Prince Charles, or then to Prince Andrew, and so on and so forth. So, the Prince William, rather. So, this is how the sovereignty devolves there. But in a democratic system, in a system what we have adopted, the constitutional democracy, here the sovereignty lies with the people. So the people of India decide, and they decide this through the method of elections, which are held every 5 years. They decide as to which government will come into power and who will be able to enjoy the mandate of the people. They give this authority that by voting, you give this authority to a certain government, that this government will be in power, say, for 5 years or thereafter. So the difference between a monarchical form of government and a constitutional form of government is that the constitution embodies that the sovereignty of people, the sovereignty lies with the people, with the citizens of that country, and the constitution is the most important document which provides for that lying of the sovereignty. Now, how did the constitution come about? We talk about constitution several times, and how different is it from any other law that the parliament would enact? So we have the parliament that sits on various sessions for a year. It normally has a tenure of 5 years, the Lok Sabha. There are certain laws, bills that are introduced within Lok Sabha, and once the Lok Sabha passes it, the President of India signs it, and it is officially notified, then that bill becomes a law. And then that law impacts our life in the manner that it is provided for. Now, what is the difference between constitution and any such law? Now, the constitution was framed by what is known as the Constituent Assembly. So by 1940, by the mid 1940s, it was clear that Britain would have to leave India, the British Empire would have to vacate from India, and it would have to grant independence. So when they decided to the transition of power from the British Empire or from the British Crown to the Indians started taking place, the first and foremost thing that happened in 1946 was creation of a Constituent Assembly. So Constituent Assembly is just like the Parliament. Parliament, that time it didn't come into force. Parliament came only in 1952. So I'm talking of 1946, just before our independence in 1947. The British government enabled creation of what is known as a Constituent Assembly. Now that assembly consisted roughly of around 400 people, and the only task of that Constituent Assembly was to frame the Constitution of India. That's it. So it was there only for a solitary task. It performed that solitary task, and after that, Constituent Assembly was dissolved, and it then no longer was in existence. So from 1946, say roughly around 9th December 1946, till say 26th November 1949, for a period of 2 years and 11 months, this Constituent Assembly, consisting of some of the brightest minds in the country, some of the most dedicated patriots in our country, they sat, they deliberated, and they formed or they created this document, which is known as the Constitution of India. So this was created by one specially constituted assembly known as the Constituent Assembly, and they deliberated upon it, and they created what is now the world's largest written constitution. So we have more than 395 articles, and that time it were 8 schedules, and today we have 12 schedules. So the written document in terms of the number of articles and volume is the largest constitution ever. So it was finally the work of the Constituent Assembly concluded on 26th of November of 1949, and that day is celebrated in India as Law Day. So we celebrate law. But surprisingly, despite the constitution being ready by November 1949, we did all the provisions, or rather 90% of the provisions of the constitution did not come into force then. It officially came into force a couple of months down the line on 26th of January 1950. And that is why 26th of January, and we are so close to that, is celebrated every year in our country as the Republic Day. So it's on the day that our country officially became a republic. So when we say becoming a republic, meaning thereby we were no longer under any limited, also direct, indirect control of any foreign government. That, for example, the British government, they finally exited from India in all its legal and political and practical significance. They were totally out, and the ultimate power vests in the hands of citizens of this country. And that is what a republic government means. A republican form of a state means that the ultimate power lies in the hands of the people. And we declare this, that yes, the ultimate power lies in the hands of the people, by formulating the Constitution of India, which came into full force on 26th of January 1950. And the reason why they waited for 2 years also is slightly interesting, because for the first time in 1929, during the Congress's Lahore session, every year the Congress party, which was in forefront of the freedom struggle, they used to have an annual session. So in 1929 December, their session was in Lahore, that time part of undivided India, today part of Pakistan. And on the banks of the Ravi, for the first time, Indians made an unequivocal, unambiguous, clear claim to the British government that we want Purna Swaraj, that is full independence, and we will not settle for anything less than that. Because there were several offers, dominion status and so on and so forth. And you would be surprised to know that today, as we speak, say Australia, New Zealand, Canada, all these very progressive countries, even the official head of these respective countries is the British Crown. So practically, for almost on all aspects, they are independent and they can run their affairs of the company. But the head, like for example, we have the president who's the head of the country. For Australia, Canada, and New Zealand, and for few other dominion countries in the world, the official head is still the British Queen. But in 1929 December, we made this a very clear and a bold declarations almost 100 years ago now, that we will not be under any rule of the British government in any manner whatsoever. And Purna Swaraj, that was the call. Pandit Nehru unfurled our tricolor, and we made a clear-cut demand to the British that we will settle for nothing less than total independence and you'll have to exit India. So 26th January 1930 was the day when this demand was officially placed. And therefore, 26th January holds a very special significance. In fact, the constitutional fathers had proposed 26th January at that point of time, hopefully to be a day of our independence. But it was, as historical events took place later on, British exited in a hurry. And 15th August then became our Independence Day. So these two dates are very important in the calendar of any Indian. 15th August and 26th January. 15th August where we became an independent country, and 26th January where we declared that the ultimate power rests in the hands of the people. We are an independent country and we will function according to the laws that are framed by the representatives of people who are elected from the citizens of this country. So therefore, this is the significance of 26th January as we approach. So it's not just any random date that was selected and and we've had the Republic Day. It was a very 15th August comparatively was random because the Britishers showed undue haste in exiting from India without putting in the place proper mechanisms. So it was only in July of 1947 that they declared that by 15th of August they will exit. And then we had a very hastily drawn partition, and everybody knows, probably it would be a subject matter of a different webinar, the problems that took place by those hasty partition that the British effected in India. But 26th January was no coincidence. It was something that was always there in the hearts and minds of our constitutional fathers, and they had envisaged this more than 20 years before India actually became independent. So this is what the foundation or the historical origins of our constitution is. Now, if you're not a lawyer and if you're not practicing into it, I would not recommend that you should delve deep into it and understand the finer nuances of the specific articles and so on and so forth. But what I would request and probably expect from every citizen of a country, and especially every educated citizen of a country, is to have a basic idea as to what the Constitution is all about. Now, my endeavor has been just to give you a brief background up till now as to how did the Constitution come about, as we say, clear the fundas, things which we know about, hear about, but we don't actually know the origin about it. But now that we have traveled from the origin of the Constitution, I would like to spend a few minutes now on what does the Constitution mean for an average citizen of this country. And for that, you don't have to go further than the preamble. Preamble is the introduction of our Constitution. So what do we propose to achieve? This lengthy document that we created after a 3-year deliberation by some of the finest legal minds in our country. So that document, the introduction of the document itself shows as to what are they seeking to achieve. What did our constitutional fathers, the founding fathers of our nation, what did they seek to achieve? And there are 4 principles, guiding principles in our preamble, that every citizen of this country now, and it's no excuse that, I am from the science background, or I am from the engineering background, or I am from the medicine background, so I don't need to know the Constitution. No, the Constitution is not for art students. You see, the Constitution of India is for the entire country, for each and every citizen, whether educated, not educated, whether from technical stream, science stream, art stream. So Therefore, a basic idea of the constitution is every citizen's duty. And what is the basic idea? As I say, don't go beyond the preamble, the very first page of the constitution, which prescribes the essence. It encapsulates, it embodies the essence of what our constitution is. And it seeks to establish what is known as justice, liberty, equality, and fraternity. These are the four ideals that every Indian, these are words that we come across every day. But then let's understand the true meaning of these words as enshrined in our constitution, and you've understood the constitution. So it's, you don't need to understand those specific articles or know the specific articles if you're not practicing there as purely as a lawyer. But every citizen should know the four very basic guiding principles of our constitution. That is justice, liberty, equality, and fraternity. And what are these? How do we expand it? Of course, every one of us would know the simple grammatical meaning of justice, of liberty, of equality, and fraternity. But in our constitutional sense, and that's the topic of today's discussion, that is our constitution, its relevance and role in the present times. So we need to revisit these basic founding principles of ours in order to understand as to what is our constitution. And if we live by the constitutional ideals, then it would create a very harmonious society, and to a large extent obviate the kind of problems that we currently face in our country. And that's because we don't understand the constitutional values in its truest sense. Now, first and foremost principle, when we talk of justice, now, when in the preamble, they talk of justice, which is social, economical, and political. So therefore, our country endeavors, the constitution endeavors, that justice should be of three dimensions: social justice, economic justice, and political justice. By political justice, of course, you know that this is how the constitution provides the right for the citizens to elect their own government. By economic justice means before our independence and for several centuries before that, we had a very feudal system where the power and the wealth was concentrated in the hands of a few, and the others were deluded and deprived from it. So our constitution also seeks to establish a very just economic order where everyone has the right and opportunity to grow and to develop and to rise economically. And more importantly, social justice. Now, this social justice is something that we in the university would come across very often, because the entire scheme of reservations that we have to face, for example, and my endeavor here is not to pass any value judgment as to what is good, what is bad. My effort here, my endeavor is only present the constitution and its certain basic principles in the manner that it is enshrined, in the manner that it was intended. Now, it's up to you all that to think about it and to decide whether what is appropriate, what should be, what should not be. That's not my role today. My role is just to inform you as to when we talk of social justice, when the reservations are provided, what the constitution also envisages is that yes, all of us shall be equal. But it does not mean that unequals to be treated equally. So the constitution does prescribe the provision for certain categories of people, and it says that those categories of people have to be treated equally. So for example, if someone comes from the general category, the constitution provides that all general category candidates must be treated equally. There cannot be any discrimination inter se between general category candidates. But it does not mean that all of us have to be placed in the same basket. The constitution provides for the creation of various classes based on their historical background, their caste background, their economic background. Various classes are created, scheduled caste, scheduled tribes, OBCs. Now we have EWS, economically weaker sections. So what the constitution says, it permits classification or creation of these various classes. And it says that those within that class have to be treated equally. You cannot discriminate. So meaning thereby, if somebody belongs, say, to the scheduled caste category, that candidate will have to be treated equally vis-a-vis all other scheduled caste candidates. And no one person within that group can be given preference over the others. So this is what the concept of social justice under our constitution is. That is, it permits classification, creation of categories, creation of classes, and at the same time says that within those classes, the treatment must be equal. No person within those classes must be favored over the others. So this is the basic concept of justice, justice which permeates social, economic, and political spheres. Then the second major principle that we come across in our preamble is liberty. Now, liberty is something very precious, for a nation that didn't have liberty for almost 150 years to 200 years while it was under the British rule. We could not write anything critical of the government. We could not form political parties. We could not form associations. We could not move about. We could not express ourselves, nor write any document, literature, nothing. Things that we take it for granted. Today, there are a plethora of rights that we just take it for granted. We open a newspaper and we take it for granted that we have the right to publish a newspaper. We have a right to read everything in the newspaper. We have a right to open our television channel, see whatever we want. We have a right to write whatever we want. Now, all those rights were not there under the British rule. And to some extent, even in the kingdoms before that. Now, in the modern constitutional sense, liberty of thought, of expression, of belief, of worship, all these freedoms are enshrined in our constitution. And that is a remarkable document because it was very easy, this is, of course, I must digress and say this is just my personal view. When partition took place, there was tremendous amount of bloodshed and tremendous amount of displacement of people from India to Pakistan and from Pakistan to India. And in those very dark times, those very difficult times, it was very easy for our constitutional fathers to be reactionary in nature. For example, when Muhammad Ali Jinnah, who's presently the father of the nation for Pakistan, when he created Pakistan, or when he sought to create Pakistan out of India, the guiding principles of our constitution is not found in their constitution. In their constitution, a specific religion is given, and officially under their constitution is given an official status, meaning thereby everyone who adheres to a specific religion there gets a higher status, and everyone who does not adhere to that religion automatically, legally, becomes second-class citizens. Now, Indians, when in 1947, when we decided to frame our constitution, we also could have gotten reactionary. We also could have said that, no, if they are going to do it for their specific religion, let's do it here in India for our specific religion. But our founding fathers didn't do that. And that's also because I think due credit also must be given to the majority community in India, that they also supported our founding fathers in creation of a secular state. Now, when we talk of a secular state, again, that's a very important facet of liberty and equality. When we talk of that, we talk that each and every citizen of this country is equal. If I'm an Indian, you're an Indian, we both, of course, within the specific categories and classes, the subdivisions are there. But broadly, both of us stand on the same footing. Now, tomorrow, if there is a question of being appointed, say, as the vice chancellor of any university, or getting into the IAS or the IPS, your religion doesn't matter. What religion have you come from gives you no extra marks or doesn't give you any extra credit. And this is a very remarkable thing that is there in our country. The ability to keep religious, caste-based, ethnic-based, language-based differences aside and to provide an equal opportunity to everyone. So it's not like if two people sit in the interview for UPSC, both from, say, Ramjas College. So one person who's of, say, the majority community, he will get some extra marks, and the one who's not from the majority community will get lesser marks. No, that doesn't happen under our constitutional scheme. Or two students from Ramjas sitting in an interview panel for UPSC, one person who speaks a specific language, say for example Hindi, he gets additional marks, and the other one who doesn't speak Hindi as his mother tongue gets lesser marks. No, even language doesn't matter. Or let's take another example, two persons again from the same category sitting before the interview committee. One fellow is rich, other fellow isn't. One fellow has come in a car, chauffeur driven, the other fellow has changed 3 buses to reach UPSC house, Shahjahan Road. So the fellow who's come in a chauffeur driven car is not going to get some extra marks. Another example, two students sitting before the interview panel. Candidate A, his father is a minister or a top-notch IAS, IPS officer, or a big shot or a big businessman. And candidate B comes from an ordinary middle-class family. Parents are usual working middle-class family people. So the candidate A will never get a head start or never be given extra marks. So this is what are the ideals of liberty and equality enshrine. That it is not just empty words, but in our daily life, be it in economic opportunities, educational opportunities, and in matter of living our daily existence, Everybody is afforded equal rights, irrespective what your religion is, what your caste is, what color you belong to. Whether, unlike in the West, where in the US, even though they had a written constitution from 1787, they had to struggle for nearly 200 years to establish a truly egalitarian society, because there, even the white race always had much better privileges compared to the non-white races, and especially the black community members, and you still see those fissures there in that country. But in India, right from 1947 onwards, when we framed that constitution till 1950, our constitutional fathers adopted these extremely forward looking principles. And this is something that we ought to understand, and that gets me to the last of the four principles in our preamble, the principle of fraternity. Now, this is one of the least understood principle, and in the present times, in my personal view, would be the most important principle. What is fraternity? Fraternity means brotherhood. And that is ultimately the goal of our constitution. It is not just an abstract document which is to be just studied for examinations and or been quoted in courts. This is a living document which seeks to impact the life of the millions of people who live in our country, to impact their life positively. And when we talk of fraternity, we mean brotherhood. We mean brotherhood which transcends all divisions of caste, of religion, of language, of ethnicity, of region, of financial differences, everything. And unless and until there is no true fraternal feeling, for example, some people from the north should have a feeling of brotherhood towards those from the south, and vice versa. People from a different religion should have the attitude of fraternity towards those from a different religion. Why? Because all of us are Indians, and that is what our constitution teaches us, our constitution seeks to achieve. That please have this brotherhood, unless and until you do not have a fraternal relation to other Indians. See, it's very easy to be fraternal towards those who are within your own caste or community matrix. That's very easy. But what the constitution urges us Indians to do is, please have this brotherhood across divides. Please have this brotherhood across all your parochial narrow divides that we learn to put ourselves in various silos. That is very important. And somewhere down the line, probably in our present terms, when we talk of a country, we talk of our country in a very abstract sense. It's not just a piece of land, from Kashmir to Kanyakumari. Our country essentially consists of the people who inhabit in this country. And this is what our constitution teaches, that at one level, when you have to dedicate yourself to the physical unity and integrity of our country in a very physical, geographical sense, at the same time, you should endeavor to have brotherly bonds between the citizens of that country. And that is what I've always emphasized personally, as someone who's extremely proud of the Constitution of India. And for me, that's my sacred book. Being an atheist, I don't follow any religion or any sacred book. But for me, the closest that comes to a religious book or a sacred book is the Constitution of India, and the values enshrined therein. And I think this is one value which will go a very long way in trying to dissipate, in trying to obliterate all the problems or the tensions that we have in our society with regards to the various conflicts. That is only if we just start adopting the constitutional principle of fraternity. That yes, this person is an Indian, and I shall have my good feelings towards him, brotherly feelings towards him, my love and affection towards him, irrespective whether he does not belong to my community, my caste, my religion. But this is the foundational principle of our constitution, which all of us must ought to learn. All of us must try to imbibe. And that's the only thing probably from today's talk, if that's the only takeaway, that loving our country does not mean loving just the mere land. Loving our country essentially means loving the people within it. And this is what the Constitution of India teaches us. And I hope this has been of some benefit to you, this talk. And I'll be glad to take any questions anyone has.
Definitely, sir. Definitely. Thank you so much for this talk. And our constitution is the Gangotri. It's like a new thing that I also can understand, or it's a new view of looking at our constitution. And obviously, it's not just about loving the land, but also the loving people. in the country. So now I request the participants, if you have any queries, any doubts, or anything that you want to discuss with the sir, you can either type it in the chat box or you can raise your hands. And of course, there is a feedback form which has been shared in the chat box, so you can also give your comments over there as well. So, and sir, just to let you know that we have crossed the 100 limit participants. So in Google Meet, we have 100 limit, but this thing is live on YouTube, and we have lots and lots of participants who have joined over YouTube as well.
That's great. That's great. That's nice.
So there is a question. Anurag wants to know about your views on marital rape cases.
No, as I said, my effort will be to just try and tell you all as to what the Constitution provides. I don't, claim to be an oracle or an all-knowing fellow who will start giving you my views. But I'll just give you. I'll place both the points of view before you, and you all decide as to which is the most the view that commends to yourself. See, those who are, we have the Indian Penal Code, Section 375 and 376, which prescribes what a rape is and the punishment for committing that rape. But there is an exception to that. Uh, the relationships between a husband and a wife do not come under the definition of rape. So there is one category of people who are currently now before the Delhi High Court who say that this is a very wrong classification. This is a very wrong exception. You have excluded marital rape from the definition of rape, and marital rape should be included within the definition of rape, because this is one important step to secure the rights of a woman, in an essentially unequal society where women have traditionally been at the receiving end, the males have been traditionally at a more powerful end of the spectrum. So they say that this exception is wrong, and you should give the right to a woman to go to the police station and complain against her husband, to file an FIR against her husband for rape, if the husband has committed forcible intercourse on her against her wishes. So this is one view. The other view, the opposite view, or the view on the other side, is that this would destroy the institution of marriage. Because what will happen is that every discord between husband and wife, if at a spur of the moment or a very impetuosity, the wife goes and registers an FIR, then the courts of our country or the police stations will be flooded with such FIRs. Because every dispute, if it leads to if it leads to filing of a case, then that is going to be that is not a very happy situation for a family life, and it will only lead to multiplicity of litigation. So there are two different points of view on this, and the ones who oppose including marital rape within a definition of 375 IPC, they also say this, that it's very difficult for the courts to realize, or the law to realize, as to what truly happens within the bedroom between a husband and wife. And another facet is that when you are not married, there is no expectation of a sexual intercourse from your partner, from your spouse. But in a marriage, there is a legitimate expectation of an intercourse with your spouse. So therefore, where does this legitimate expectation end and where does the consent begin? So it's an extremely gray area. So of course, the Delhi High Court currently is debating on this. There is a hearing going on almost on a day-to-day basis, and very soon we'll come to know the judgment. But there are good points and bad points on both sides, and I've presented it before you all.
Correct. And I think, sir, the same thing will go with the live-in relationships as well, because over there also there will be no like legitimate line that you can draw.
Correct. You're right about that. But live-in relations are not given full protection of law like marriages are. So, for example, if a man and a woman is in a live-in relationship, the woman can still go to the police station and complain that she has been raped, and that complaint can be registered against the live-in partner. But if both of them were to be married, she cannot go to the police station and complain that she has been raped by the husband. So there is still one minor distinction between a live-in relationship and between a husband and wife on this aspect.
Okay. Then there is a question by Hiya. She's asking that the word secular that has been added into the preamble, was it during the emergency time?
Yes. See, the word secular was officially added in our constitution by the 42nd Amendment in 1976. Then emergency was there. Emergency is 1975 to 1977, roughly around that time. So it's during the emergency this was, but it really doesn't matter because you see, even if on 26th of January 1950, when our constitution came into force, and the word secular wasn't there, it didn't mean anything because the constitution was secular. So even if that word wasn't there, each and every article, the underlying thread, the common link which linked the entire constitutional document was that it was on a secular basis. Because if it wasn't, then it would have given, as I said, the constitution of Pakistan or constitution of Bangladesh or Iran. They in their constitution they officially give a higher status to a specific religion, which is not there in our constitution. In fact, Article 14, Article 19, Article 21, Article 25, 26, 29, 30, 32, and I can go on and on and on. There are several articles in our constitution that repeatedly emphasize our secular character. That, sorry, nobody gets a head start because of your religion. Nobody gets a specific treatment because of your religion. So in 1976, what they did was, what was already there, it was just an official word that was introduced. But even if that word was not introduced, or even if you delete that word, it doesn't matter, because what matters is each and every article of our constitution lays down a secular path for our country. So therefore, so yes, technically you're right, that word was included, but it doesn't really matter whether it was there or not there. Our constitution till date is a very secular document.
And sir, another question is like, what are your views on this inheritance laws when the property is being passed on to the daughters, the Hindu Succession Act, and what are your views on this act?
No, as I said, my view counts for nothing. What matters is the view of the Supreme Court. So you see, so what view they hold is the law. What view your Mr. Sunil Fernandez holds is not the law. It really doesn't really matter.
Probably, I think the student wants to ask if you can explain this
Yes,
in
yes.
very
So
simple
correct,
terms.
correct. So you're right. So that's what I said. So whenever you ask what my view is, I presume that you would like to know as to what the legal position is. So the legal position here is this: that we had the in 1950s under Pandit Nehru, several laws pertaining to Hindus were officially codified. When we say codified, means the Parliament passed laws which would govern Hindu marriage, Hindu succession, Hindu divorce, Hindu maintenance, etc., etc. So one of those aspects was in 1956 when we had the Hindu Succession Act, which laid down as to how the property would devolve from the father to the next generation. So there was a dispute with regards to whether the daughter would be able to get a share in the father's property. And now, in a very recent judgment, of course, there were judgments earlier which said that yes, he does have a right to inherit the father's property. But in a very recent judgment 2 days ago, Supreme Court has said that even if the father has expired prior to 1956, prior to the Hindu Succession Act coming into force, even then the daughter would be entitled to the properties of her father. So this is a very progressive judgment, I would say. I mean, if I can just present my two-bit view on this, that ultimately the rights have to be equally placed for all the siblings.
Okay. And sir, there is another question, like since you have dealt with the Sabrimala case, so can you throw some light on that case?
Correct. See, although I was the advocate on record, or we argued in favor of entry of menstruating women into Sabrimala, but I'm not going to, of course, seek to brainwash anybody or just trumpet my point of view. I'll present both the points of view, and then again you all can decide. See, but so the petitioners, the ones whom I represented, who wanted entry of menstruating women, is that the DT, the shrine, prohibits the rules and regulations prohibit entry of any woman who is of a menstruating age. And the case before the Supreme Court was that this is a direct violation of Article 14 of our Constitution and other such constitutional provisions which talk of equality. And you can't exclude such a major chunk of our citizens from the right to worship the deity. So this was the petitioner's side of argument. From the other side, the ones who wanted to maintain this, they said that this tradition has been going on for several centuries, and the god, the deity over there, he has certain unique features. That is, he is a nestic brahmachari. That is, by his very the very trait, the very ideal of the deity is such that he cannot give darshan to women of a certain age, that is a menstruating age. And the courts are nobody to interfere in the private practices or the religious practices. If supposing the Hindu community or that community in Shabrimala is of the view, they have this faith that this is this deity and this deity does not give darshan to menstruating women, the courts do not have any authority to replace that religious view with their view. So these were the two divergent points of view that were argued. Ultimately, in the first round of litigation, Supreme Court in 2018 came up with a judgment striking down all such barriers for the entry of menstruating women in Shabrimala. But then what happened was, when a few ladies did want to, of that age, menstruating age, did want to visit Shabrimala and take darshan of the deity, there was a law and order situation, and there was a threat of being physically harmed and killed and so on and so forth. So therefore, they could not go. It was a law and order situation. The state of Kerala came back to the Supreme Court, and the Supreme Court has now put this case before a larger bench. The Shabrimala judgment of 2018 was by a 5-judge bench. Now it has been placed before a 9-judge bench, and various other issues are being debated, with not only with regards to Shabrimala but also with regards to religious practices against females in other faiths also. And that will be heard by a 9-judge bench. And as and when the Chief Justice of India constitutes a 9-judge bench, they will hear that matter and they will hear all those questions that are being formulated, including the question of Shabrimala. So today we are in a bit of a limbo, although the judgment is there, which says that ladies are allowed to menstruate, ladies of a menstruating age are allowed to take darshan of the deity, but because there is no security provided to them and there is a threat of violence, they are not able to go. And since the Supreme Court also has not come to the aid of such persons, because they have placed this matter before a 9-judge bench, so things, to describe it very accurately, are currently in a limbo. So you have the legal right to go, but that legal right cannot be enforced, cannot be practically enforced. You practically won't be able to visit it.
Sir, just a clarification. It's the woman in the menstruating age or the menstruating woman as well? Because it's only few days when a woman menstruates in a
No,
month.
no. There is no. I get your point, because the other temples normally, women during that period of a month, they normally don't visit it. But that's not the case here in Shabrimala.
Okay.
It doesn't matter whether you are menstruating on the day when you seek to visit the deity. You are prohibited from entering as long as you are of a menstruating age. So I think it's roughly between 14 to around 48 or 50. That's the age group which is excluded.
Okay, okay. And sir, there are many questions which are coming in the chat box. So I first want to ask you, like,
Yeah, sure, sure,
should
sure.
I?
Please shoot, please shoot. I'll quickly
Okay.
try to give answers to all
So
of them.
one question is from Chitran. He's asking, can we say that fraternity is a vital component of constitutional morality, and how can we relate constitutional morality with constitutionalism? So
See,
if you could
again,
first explain what this word
I know, and
constitutionalism.
as I said, without getting into too many semantics, without getting into too
Hmm.
much, into the definition. As I said, because this is not an academic class, this is just an easygoing chat. I'm just wish to share a few ideas and certain information that I have with you. So when we talk of constitutional morality, it's nothing but our constitutional values. And this word was used for the first time by Dr. Baba Sahib Ambedkar, who was the chairman of the drafting committee in the Constituent Assembly. So I remember I told you about how the Constituent Assembly framed our constitution. So there were various committees within that Constituent Assembly. The most important committee in that was the drafting committee. And Dr. Baba Sahib Ambedkar was the chairperson of that drafting committee. And he said that, and this is where when we talk of constitutionalism and constitutional morality, when you talk of constitutionalism, you probably go by what is written in the text. Now, in the Constitution of India, the text, there is no line that you would see which would say that you cannot prohibit menstruating women of a menstruating age from entering any temple. That's not written anywhere in the Constitution if you go by strictly the constitutional text. But when you talk of constitutional morality, you have to understand what is the spirit of that constitution. What does the constitution seek to achieve? You see, so when you talk of constitutional morality, what we are trying to say is, don't just go by the strict letter. You should go by what the constitution as a whole seeks to achieve. What is this ultimate objective? What is its ultimate goal? What does it aspire to create? And those values are what is known as constitutional morality, where you transcend, the letter of law, and look into the spirit of that law. You see? So that's also, for example, just to give a very loose example, say, say drinking is prohibited. Say if the letter of the law says you shall not carry any alcoholic bottle within the college premises. But supposing somebody carries alcohol in a bottle of Pepsi or Coke, so so isn't it? So you can argue at one level that no, see, the rule is that you cannot carry an alcoholic bottle, and you show a bottle of Pepsi or a bottle of Coke and say, see, this is not an alcoholic bottle. You see, but what is the spirit of prohibiting an alcoholic bottle? It's not the bottle. The spirit is prohibiting the alcohol itself. So when you're carrying it in a different form, you are violating the morality of that law. You see? So this is what constitutional morality is all about. Just not merely going strictly by the letter, what is there in the constitution, but its underlying spirit. And this is where, as I said, fraternity, just the underlying spirit, loving our fellow citizens and not merely loving the land and saying that I am a patriot or I'm a nationalist.
Sir, there is another question like, can we connect justice with power and power with social, economic, and political things? Because
No, no, you can, provided you call me for a separate webinar, keep this as a separate topic, and then I will deal with it.
definitely, I mean, I think the students are very much interested in talking to you, and
So,
we
so
will be
this is,
very happy if you can
yeah,
spare time
yeah.
another
So,
for another session.
yeah, so please, so kindly excuse me. In a question and answer session, I can only answer a question. I can't actually speak on a separate topic, altogether. So, kindly. So, I think we should go to the next question.
Okay, there is a question by Ojit sir. He is faculty at Ramjas College only. Sir, do you think that our present constitution has an efficient tool to make ourselves adapt to the changing conditions, as for example, the climate crisis? So, if you can comment on that.
See, my short answer to this, and this answer is consistent every time, is the Constitution of India can only do so much. Ultimately, it boils down to the people of country. To you, to me, to everyone else. So the Constitution cannot create better citizens out of us. It can only create a roadmap. But ultimately, it can only create a road. But it's you and me who have to walk on that road. If we refuse to walk on that road, no matter what constitution is created, it will not work. So at the end of the day, it all boils down to the citizens of this country, to the people of this country, that do they want to follow our constitutional ideals or no? So if they don't follow our constitutional ideals, either because of ignorance or either because they reject it, then the constitution is nothing. It's meaningless. After all, it's just a book. You see? So therefore, just to answer this question, no matter how many laws we have, how many rules and how many regulations we have, it all boils down upon us. If we are ready to make the constitution work, it will work. If we are not willing to make it work, it won't work. No matter what you write in that.
Sir, I think I should take just one last question because there are lots of questions which are coming up and we are
Yeah.
running out of time. So usually it's being said that justice delayed is justice denied, and it's the question of Hirsch. So up to what extent this context is true, especially given the way the judicial system functions?
See, you can't run away from this fact that justice in our country takes a very long time to come to fruition, to come to reality. And that is a very unfortunate part. And you can't solely blame the judges in this because, just to give a rough example, say in America, there is one judge for every 10,000 US citizens. That average in India is around 4 to 5 lakhs. So just look at the sheer difference in workload. And we're talking of a country which the ones in the US would have far better technological access compared to judges here. So despite much better technology, the ratio over there is 10,000 is to 1, whereas ratio in India is a few lakhs per judge. So first and foremost is the sheer pressure of population on our courts. That's number one. And number two, also because of certain long-standing practices, certain economic reasons, the courts in our country shy away from imposing heavy costs on a losing party. So that's why litigation becomes very easy. And I'll give you a very, very quick and a very simple example. Supposing I'm a tenant in a landlord's this thing, and at the end of my tenancy period, I'm supposed to vacate. I refuse to vacate. Now the landlord files a case. Now, by the time the case is filed and by the time it goes through the various levels, lower court, high court, Supreme Court, 2-3 years at least, if not more, are spent. And I get to enjoy for another 2-3 years as a tenant. You see, so even though whatever rent I may pay, but at the end of the day, the landlord has had to endure a long litigation just to get hold of his property. The vice versa also may be true. Maybe the tenant has vacated on time and certain deposit is lying there with the landlord. Landlord refuses to pay back the deposit. Then the tenant has to initiate a case. Again, it goes through a very lengthy, torturous process, lower court, high court, Supreme Court, and at the end of that, supposing if he pays, so there is no penalty, no adverse consequences in our system. So this encourages people to act dishonestly and just enter into needless, frivolous litigation. So the two major problems is first and foremost a huge population pressure, and corresponding to that population pressure, we don't have a judicial infrastructure. The governments have not allocated requisite funds to create more courts, more judges, and so on and so forth. And secondly, the judicial ethos in our country, the legal ethos in our country, where you litigate and the losing party does not suffer. Like for example, in the West, the losing, especially US, in the European jurisdiction, the losing party has to really cough up the entire expenses of the winning party as well as for the courts. So but here they don't do that, because it's not considered to be financially very viable. So that's another reason why a lot of frivolous and useless litigation also takes place in our country.
Okay, sir. I guess, so principal sir, if you allow me, can I ask one last question from my side, and then we can bring the session to conclude. Sir, you are muted. Uh, Principal sir, you are muted. We can't hear you.
So I think we should restrict to time also because his time is very precious.
Okay.
And
No, I can take one question, no problem. I think she's asked everyone else's questions. Only fair
yeah,
that she gets to ask her question.
Thank you,
Please.
sir. So this is like a question which, in general, everyone is having. Like we usually talk about our rights. Like this is our right. We have to do this. And whenever we go on any kind of strikes or dharna, we always say कि हम अपना अधिकार मांगते, किसी से भीख नहीं मांगते, and all these things. So we usually talk about our rights, but not our duties. So can you just give some light to the students? What that our duties are also important in that space.
Correct. It's a two-way street. This is where probably when we all are students, we are not probably adequately sensitized or we don't appreciate it. See, when we talk of rights, it's just one part of the coin, one side of the coin. Every coin will have two sides. One would be right, and the other part would be of duty. So there is no right which does not come with an accompanying duty. And the only point I would urge my friends over here is, most of them students, is when you talk of rights, don't just look at one side of the coin. Also apply your mind to what is on the other side, which you are refusing to see. Because each and every right of yours comes with an accompanying duty. And when you are able to balance the both, the right and the duty, that's when you have taken your first step as a responsible citizen of this country.
Thank you, sir. Thank you so much. Now, I would request our Vice Principal, sir, and the coordinator of IQAC, Professor Hemant Kumar Rajor, to please give a vote of thanks.
Thank you, Apurva. On behalf of Ramjas College, I, Professor Hemant Kumar Rajor, Coordinator IQAC and Vice Principal, extend my heartiest thanks to the speaker for the today's session,
Thank you. Thank you.
Advocate Sri Sunil Fernandes, Advocate on Record, Supreme Court of India, for giving such a wonderful session. You have explained most of the things in such simple ways, and I believe that our teachers, non-teaching staff, and students would have benefited a lot from this webinar. And I hope that we have contributed towards creating sensitization about our Indian Constitution among the participants. I would like to thank our principal, Professor Manoj Kumar Khanna, under whose guidance we have conducted this webinar and who constantly motivates us to to both our rights and duties. I would like to extend special thanks to Dr. Kumar Rahul, helping us in organizing this webinar. And lastly, I would like to thank to Dr. Apurva Gupta and Dr. Shashank Kumar Maurya, who helped out in smooth conduct of this webinar and making it live on YouTube. Thank you very much.
Thank you.
Thank you so much, sir.
Thank you.
Uh, Thank you. To the participants, there is a small request. We have shared the feedback form link in the chat box. We request all of you to please fill in that feedback form. And sir, thank you so much for giving us such a nice talk.
Thank you. Thank you.
Sunil ji.
Thank you. Thank you. Thank you.